2025 Asylum Crackdown: How new DHS rules are changing the system. A new phase for asylum policy. Across the United States, the asylum process has become a defining subject of immigration debate. Under President Trump's second term, it has entered one of the most restrictive phases in modern history. The administration says these reforms are designed to restore control and reduce abuse. Critics argue they weaken humanitarian protection and make legal access harder for people fleeing persecution. Early 2025 brought sweeping DHS directives expanding expedited removals, tightening asylum interviews, and adding algorithmic screening. Together, they mark a structural shift toward a faster, security-driven system focused on verification over compassion. Fast-track deportations nationwide. The first major change is the expansion of expedited removal. This allows immigration officers to deport people without a hearing if they cannot prove lawful entry or 2 years of continuous presence. Previously, this authority applied only near the southern border. Now, it extends nationwide, giving DHS power to detain and remove individuals anywhere in the country. Human rights attorneys warn this blurs the line between border enforcement and domestic policing. They say it risks detaining long-term residents who may have legitimate protection claims but lack immediate evidence. Officials defend the policy as essential to deter illegal entry and reduce court backlogs. Yet advocates note that proving 2 years of residence while in custody is nearly impossible without documentation or witnesses. For many migrants, a single roadside stop or workplace inspection can now trigger rapid deportation. The rule has effectively turned interior cities into new points of enforcement beyond traditional border zones. Tougher, credible fear screenings. Another major change involves the initial credible fear interview. This first screening determines whether an asylum claim proceeds to a judge. Applicants now face a higher evidentiary threshold than in previous years. DHS argues this deters fraudulent filings and accelerates legitimate ones. However, advocacy data show approval rates have dropped by 30 to 40% compared with 2024. Legal aid groups warn that people fleeing war or persecution rarely arrive with documents. Under the new standard, their inability to provide immediate proof often leads to denial at the first stage. Applicants describe rushed questioning, limited interpretation, and little opportunity to explain their stories. Once a case fails this interview, deportation can occur within days, leaving almost no room for appeal. Border processing centers and legal access. To apply these rules quickly, DHS opened new border-based processing centers operated by Customs and Border Protection. These sites handle asylum screenings within days of arrival, cutting months off older timelines. Officials say the centers improve efficiency and reduce overcrowding. But attorneys report restricted access, often limited to short phone calls instead of in-person meetings with clients. Without direct representation, many asylum seekers struggle to understand questions or gather supporting evidence. Advocates insist that legal access is a constitutional safeguard, not an optional convenience. Inside several facilities, migrants describe rapid questioning and confusion over procedures. One Honduran mother said she was asked questions so fast she could not finish an answer before another began. Civil rights groups continue urging DHS to balance efficiency with fairness. The department maintains that operational speed and security justify the limited access policies currently in place. The return of third country transfers. Another controversial measure is the revival of third country transfer agreements. Under these arrangements, certain asylum seekers must wait in other nations while their U.S. cases are processed. In 2025, DHS expanded partnerships with countries such as Ghana and Uganda. Transferred migrants are placed under regional protection programs rather than processed inside the United States. Supporters claim the policy eases pressure on U.S. facilities and discourages irregular migration. Critics argue many partner countries lack capacity to ensure safety or fair asylum hearings. Multiple lawsuits have challenged the transfers, citing potential violations of domestic and international refugee law. Until those cases conclude, DHS continues operating the program under existing bilateral agreements. For affected individuals, this means extended uncertainty and possible exposure to risk in unfamiliar countries. The debate over legality and morality of these transfers remains unresolved. Refugee resettlement temporarily suspended. For fiscal year 2025, the presidential determination still authorizes 125,000 refugee admissions. However, a January executive order suspended arrivals pending a national security review. While the cap remains, the pause has effectively frozen the program. By mid-year, fewer than 7,000 refugees had entered the U.S., the lowest number in decades. The administration calls the review a safety measure to improve vetting. Humanitarian groups say it leaves thousands stranded despite prior approval and years of background checks. Resettlement agencies dependent on steady arrivals have reduced staff and operations. For refugees waiting abroad, family reunification is now indefinitely delayed until processing resumes. The suspension demonstrates how administrative pauses can halt humanitarian programs even without lowering admission caps. Its impact extends far beyond numbers to real families separated by prolonged uncertainty. Immigration courts under strain. Inside immigration courts, pressure has intensified. New Department of Justice guidelines link judicial performance reviews to the number of cases completed annually. The backlog now exceeds 1.6 million asylum cases nationwide, the largest in history. Judges say numeric quotas threaten due process by prioritizing speed over careful consideration. Judicial associations have filed formal objections, arguing that rushed timelines increase errors and appeals. They believe complex asylum cases require context, not production targets. DHS and DOJ respond that faster decisions are needed to restore system credibility. Observers counter that justice delivered too quickly risks inconsistency and long-term distrust in the process. This tension between efficiency and fairness defines today's immigration courts. How policymakers balance it will determine the sustainability of the new system. AI screening and fraud detection. DHS has also introduced artificial intelligence systems to screen asylum applications. These tools analyze text patterns, duplicate statements, and document anomalies to detect possible fraud. Officials believe automation strengthens credibility and exposes organized misuse. Privacy advocates warn algorithms can misinterpret similar stories from people fleeing the same conflict. Civil rights groups have requested transparency about how models are trained and reviewed. They argue biased data could lead to wrongful denials for genuine applicants. DHS says humans still make final determinations and that AI only assists officers. Nonetheless, the technology marks a significant step toward a data-driven asylum process emphasizing pattern analysis over narrative context. The human impact. For many asylum seekers already in the U.S., the new framework has created anxiety and confusion. Cases move faster, evidence demands are higher, and contact with lawyers is harder to maintain. Community organizations report increasing emergency requests for legal help. Yet the speed of enforcement often prevents them from reaching detainees before removal proceedings are complete. Families describe living in constant uncertainty, unsure when or where enforcement might occur. Advocates continue building rapid response networks to provide immediate legal and translation assistance. The new environment favors preparedness and documentation. Applicants who understand procedures and collect evidence early stand a better chance of protecting their status. Looking ahead. Experts view these policies as a turning point in America's definition of asylum. The focus has shifted from humanitarian discretion toward strict screening and verification under accelerated timelines. If ongoing court challenges succeed, certain provisions may be revised or overturned. For now, the 2025 framework remains active, making timely legal guidance essential for anyone seeking protection. For applicants, the lesson is clear: preparation matters more than ever. Those unable to prove their claims quickly risk losing eligibility before reaching a judge. Community organizations are adapting with workshops, documentation drives, and outreach programs. Their goal is to preserve fairness and awareness within an increasingly procedural system. As one immigration attorney put it, the new rule is simple but unforgiving. If you cannot prove it immediately, you may never get another chance. Closing remarks. The 2025 asylum overhaul has reshaped the U.S. immigration landscape. It introduced nationwide fast-track removals, higher screening standards, suspended resettlement, and artificial intelligence oversight within a single policy year. Whether these changes bring long-term stability or trigger further legal conflict remains uncertain. What is clear is that America's asylum system now operates faster, narrower, and with far less flexibility than before. If you found this update useful, don't forget to hit like, subscribe, and turn on the bell icon for future updates. Thanks for watching, and see you in the next video.